Good evening. Can everyone hear me? Very good. Well, thank you very much for joining me. My name is attorney Wendy Guthro. I'm an estate planning, probate, estate administration. I'm an elder law attorney with my physical office located in Burlington, Massachusetts, but I do a lot of virtual work. So today we are going to speak about beyond the funeral, legal and financial steps to protect your future. It's likely that many of you are joining me because either you've lost a loved one and that you are trying to move on beyond the funeral to figure out what are the next things you need to protect yourself both legally and financially. And then another sector of you are likely that you want to prepare, you want to know what is coming down the pike, what you should be doing. A lot of the things we're going to cover today are going to be things you can also take care of during your lifetime to prepare. But this presentation is primarily geared towards after you have lost someone that's important to you, and that oftentimes your legal affairs and financial affairs have been intertwined with them. So we're going to try to get you on your way to your next steps. There is a chat feature. If you would like to put anything in the chat, you're welcome to. We will have a question and answer period at the end. If you could pop your questions in there, or we can all unmute at the end and I can directly answer questions. So let's get on with the presentation. As I said, I'm Wendy Guthro, licensed practitioner in Massachusetts and New Hampshire. The law we will be speaking about today is Massachusetts-based law, because we are going to talk a little bit about some of the taxing thresholds. I'm a member of the National Academy of Elder Law Attorneys, as well as the local and district bars. So the objective of our webinar today is to guide you through the legal and financial steps that need to be taken after you lose a loved one, and then to learn what you need to do to address immediate as well as long-term responsibilities, all with the goal of protecting yourself. So here is a roadmap of where we're going. It's the funeral and death certificates are things that need to be taken care of immediately. Your to locate your will and trust, identify the personal representative. That's the new term. It used to be called executor, executrix. Now it's personal representative. And then if you have a trust, that person would be called the trustee. We're going to talk about how to secure assets and notify people, organizations or agencies that are involved. We're going to talk about the difference between probate and trust administration and whether you have to do either or both. We're going to talk about paying debts and taxes. We're going to talk about simple distributions of inheritance, whether it's in a will or in a trust, or if there is no will. And then we're going to talk about it's important for future planning for you to update your own plan. So immediate responsibilities after the funeral. We're pretty much coming into this with what's next, but at this point, if you have recently lost someone, that you have already reviewed if there were any prepaid funeral arrangements, and that a cremation or a burial has taken place, you've held the service, you've reached out to close friends and relatives, and that you have likely started to gather some of your legal documents. So this presentation is really going to talk about what's next, right? After we've done those very difficult things. And now it's time to shift from your immediate needs to what is next. So it's the legal steps that are next, the financial organization that I need you to take an accounting of, and then we're going to talk about protecting your own future. So legal steps, the first 30 days. If possible, because if possible is very important, because if you're in a grieving cycle, for you to think about doing a lot of things after your loved one has passed away just a month ago, it's somewhat impossible for some people to do that. So this is in a perfect world if you could do things 30 days after someone passes. This is what your roadmap is. So if it's not possible to do these things in 30 days, you're going to do them whenever you can. So we're going to secure death certificates. Oftentimes this is secured with the funeral home. They're normally asking you how many you want, or it's part of the cost that you have paid for the services. Then you want to locate the will or trust of any legal documents that the decedent left. I'm going to use the word decedent. That is the name, the legal name of someone who has passed away, the decedent. And then in those legal documents of the decedent, I want you to identify, they're called fiduciaries. Executor, executrix is the person in the will, but it's now called the personal representative. If there's a trust, we're going to be calling that fiduciary the trustee. You're going to notify Social Security and the employer of the decedent if that is applicable. Social Security has normally been notified by the recording of the death certificate, either through the funeral home or through the town clerk where you live. And that normally sets up other activities, such as that the decedent Social Security will often stop. And then you will need to contact Social Security to make arrangements for any change in Social Security benefits. Oftentimes, it'll be that if there were two spouses and one of them passed away and they were making more with Social Security, then oftentimes you can secure the higher amount of the Social Security as a surviving spouse. These things also apply when you have a child that is on disability. And especially if they were a minor child, there's other benefits for them. But notifying Social Security of the passing of the decedent, as well as researching what benefits might be available to you as a surviving spouse or child. Then I want you to start to think about managing your assets. To begin a list of what assets the decedent owned, if they're different from the assets that you owned, as well as what debts have to be paid. And we're going to assemble that information because you need to start thinking sometimes within this first 30 days is, can you afford to continue living where you are? And even if you can afford to do that, do you want to do that? Should you do that? What other living opportunities are available to you? Maybe you have been on a senior housing list in the town or community areas that you're in, and that you've been waiting for a residence to come available. So that you want to start thinking about what is available, whether you want to stay where you are, and then we will have started to put together your assets and your debts to determine what you can afford. It is not uncommon for there to be a big change in financial circumstances on the death of the first spouse, or partners if you live together, or a parent, obviously, if there is a minor child still living, or a parent and child that live together. And that if there was Social Security benefits coming into that household that helped support paying all the bills. And now the parent has passed away, and now we have a child living there under their own income. So, do they have enough money to self sustain in that living environment? The death certificate is a crucial document needed for various processes. As I said, you're normally going to obtain them from the funeral director. Some clients come to me years later and they're just getting around to doing a probate administration of an estate and they don't have a death certificate. You should go to the town or city clerk in the town or city you live in and request a death certificate. You can normally get them the same day, if not instantaneously, when you are at the counter. I know in Burlington, it costs, I think, less than $25 to obtain a death certificate. So depending upon the amount and type of assets that the decedent owned, you'll likely need multiple copies to handle different affairs, such as insurance claims, bank accounts. We need to transfer property and record a death certificate at the Registry of Deeds. So depending upon the amount of assets that the decedent had, that will determine pretty much the number of death certificates you might need. We want to locate the will or trust of the decedent. If you cannot locate these documents, you simply need to either contact the decedent's attorney, um, or look high and low. Oftentimes you'll find it in a fireproof safe. Some people secure them in a safe deposit box, which we do not normally recommend because we oftentimes need a lot of those estate planning documents, such as the will or durable power of attorney, immediately, either when someone prior to death or right after someone passes away. So having them in a safe deposit box and only having the decedent having access to that safe deposit box could be problematic. So you want to have those documents accessible, and that when we're going through them and we're looking to see if there is a will or a trust, we're recommending that if you can't find those documents, sometimes the original documents are still at the drafting attorney's office. So that is another place to look for it. Oftentimes they'll be in a binder or folded in a trifold and stowed away in a filing cabinet with important papers. And sometimes there will be no will. So looking high and low will yield you no results. So that is another concern, but that the government already has a plan in place of how the assets will be distributed, even if there isn't a will. If your loved one had an attorney, or named a personal representative or a trustee of the estate, you want to reach out to that person for guidance, because oftentimes, if, say, you have a trust and you have named a child as a trustee, you could have brought them into the loop of them being a trustee, and you or your spouse or the decedent could have discussed the terms of how your estate was going to be handled upon your passing. The personal representative or trustee is responsible for managing the estate and ensuring that assets are distributed according to the terms of the trust or the will, or without a will, following Massachusetts probate procedures and the statutory dictate of how assets will be distributed without a will. So the personal representative or the trustee, those terms are also referred to as fiduciary. So if I use that term through the presentation, it could be referring to either one of those positions depending upon what documents you have. You want to assemble a list of your assets, your debts, your income, and your insurance policies, because these will help you make decisions of whether you'll be able to stay where you're at, afford to be able to stay where you're at, but it's also going to help you prepare for estate or trust administration and transferring assets either to yourself, if you are the surviving spouse and beneficiary, or whether we will be making transfers of assets to other named beneficiaries. Now we're going to talk about probate and estate administration, because once you have kind of gotten all the documents together, gotten your finances together, one of the things that has been determined is how each asset is titled, right? If it's a jointly owned bank account, if the decedent owned that bank account in their own name, if there was a life insurance policy but it had a named beneficiary. And the titling of every asset determines whether it's going to be considered a probate asset, and we're going to use the probate court and your will to, or their will, to determine how assets will be distributed, or if there is a trust, and then we can administer assets through the trust, or if it simply has a beneficiary designation, whether we're not going to be using probate or estate administration. So we recommend that you contact an estate attorney or the fiduciary and to determine is probate or estate administration needed. As I just said, the personal representative, previously the executor, controls the probate assets that pass through the will, and it uses the probate court to distribute the assets. Conversely, if you have a trust, a trustee controls trust assets that are held in a trust and distributes those assets privately without using the probate court through the beneficiary designations that you have indicated or the decedent has indicated in their trust. It's not uncommon for you to have an estate administration that does not involve probate, especially if you have a trust and during your lifetime you have transferred all of your assets into your trust. Sometimes, though, you will need to also do probate if one asset that was individually owned by the decedent without naming a beneficiary of that asset. So that one asset is hanging out there on its own that is just in the decedent's name. You are going to have to do probate for that one asset, and then you will be able to administer the rest of the estate under trust administration. File for probate if it's necessary, depending upon how assets are titled, you may need to file for probate. And probate is the legal process of taking the decedent's will, or if they don't have a will, just taking other court probate documents to the court and administering. First, the court has to validate the will, right? So you take it, you submit it, and they determine whether it was validly executed and whether it is considered a valid will that can now be followed. And again, as I've said a number of times, if there is no will, then we're just making sure that the person that has submitted the probate paperwork to the court has the authority, what they call standing, to actually act in the capacity of the personal representative and distribute the assets of the decedent. So all of that is done with the oversight and oftentimes approval of the probate court. So this is supervised or unsupervised administration of a will or no will through the probate court. So a will opens up probate. Assets that are jointly titled or have a beneficiary designation on them, such as an insurance policy, oftentimes a retirement account, or is held in trust. Those assets usually avoid probate and they are transferred privately to the named beneficiary without involving the probate court. People often ask, what about the house? Is that a probate or a non-probate asset? Well, again, you have to look at how the house is titled. If it's the sole ownership of the decedent, you're going to have to go to probate to get that transferred to the new owner's name. If it's joint tenancy with a spouse, that's also referred to as tenants by the entirety, then that's automatic ownership is passed to the surviving joint tenant upon the death of the decedent. But even if you both own a house, or if there's a brother and sister that own a house together, or a parent and a child, then you do need to check on the tenancy, right, if it's jointly owned, but you still may need to clear title. And that means telling the registry of deeds that one of the joint owners has passed away. And you normally need to do that by recording their death certificate and an affidavit that there was no estate taxes, federal or state, due when the decedent passed away. And we'll get to taxes in a little bit. So if the trust owns the real estate, so if any of you are my clients and you've done trust work and you have real estate, you know that I am a big proponent of having my office transfer the deed to your home into your trust so that we are avoiding probate on the real estate. And so then the trustee manages the distribution of the house within your trust to whomever you have named in your trust document. I do like to remind everyone, though, that to consider mass health estate recovery, if the decedent received public benefits, if they received mass health benefits during their lifetime, it is very likely that mass health can make a claim against the probate assets through the estate recovery process. So if you're thinking that there has been mass health, Medicaid services rendered on behalf of the decedent, even if we have a will that's stating that there's, thousands of dollars that are going to be distributed to the named beneficiaries in that will, if the decedent incurred uh, Mass Health Medicaid services during their lifetime, Mass Health does have the right to step in through an estate recovery process and be made whole for the services rendered through the probate process from the assets that are held in the probate estate. What about beneficiary accounts? We spoke about those a little: life insurance policies, retirement accounts, payable on death beneficiary designations on bank accounts. They all pass directly to a named beneficiary, and we do not use the outside probate process. Food for thought is that if you did name someone as a beneficiary on any of those assets and they have predeceased you, then you might have to go to probate on those assets unless you have named who is going to receive those assets in the event that the first named beneficiary has passed away. Another concern is that if you're trying to name someone as a beneficiary and they are a special needs person, and that if you give any money by leaving them as a named beneficiary and they're on public benefits or they're a disabled individual, that you could potentially kick them off of their public benefits by giving assets directly to them in their name. So if that individual had a supplemental needs trust or a special needs trust, you want to make sure to name their supplemental needs trust as the beneficiary of those assets upon your passing. And as a caveat, you do have to make sure that that trust, supplemental needs trust, has special language in it that it can receive, especially retirement benefits. So we want to check beneficiary designations regularly on our assets, especially for a supplemental needs person, or if someone was not one and has become one, then we might want to think about, do we want to change the beneficiary designation so as not to kick somebody off of public benefits from receiving an inheritance? I oftentimes see that situation with grandparents leaving money to a child, and then that child maybe develops, a disability later in life, or it's a special needs person, even at a young age. That we want to set up standalone special needs trusts for these individuals and then allow the grandparents to name the supplemental needs trust as the beneficiary of those assets when they pass away. I wanted to give a graphic depiction of the difference between probate and estate administration. So many clients, as I said, think that if they have a will, they're not going to probate. But it's completely opposite. If you have a will and you have assets that need to go through the will, such as a house that was owned only in the decedent's name, then you're going to bring that will to the probate court, have it authenticated, and then the court is going to then oversee the distribution along with the personal representative to the named beneficiaries. Why people don't like probate is that it's costly. It takes at least 1 year because your estate has to be opened up for creditor claims to make a claim against your estate, such as Mass Health. It's a public process. Whatever you put in your will, and the distributions and who's receiving it, that those are public record, and anyone can go onto the court website or petition the court for a copy of the will and the distributions and the probate record itself. And that there is normally no asset protection planning in a will. So probate, a little bit more involved, costly, at least 1 year. So if we are currently dealing with someone having just passed away and you are going to have to go to probate because maybe you went to go empty out the bank account and the bank said, oh, not so fast, you're not on that account. and you bring them the will, and you say to them, but I am in charge, I'm the executor, executrix, a personal representative. They say that's not enough. You have to get a letter of authority issued from the court that says that the will has been authenticated and that there has been no contest for you being appointed as the personal representative of the estate, and that once that all of those roadblocks have been cleared, you will receive your letter of authority from the court, and then you can go back to the bank with your letter of authority. And then you then are the holder of the money. And then if you are also the named beneficiary on the will, then once all of the debts and taxes are paid, you will then be able to distribute the money to yourself. Conversely, for estate administration, often used with a trust, the trust document and the retitling of the assets, such as the house in my previous example, that goes into the trust. And then upon the decedent passing away, the peaceful trustee, successor trustee, is appointed, and they will corral all the assets together that are already held in the trust. They will immediately be able to make distributions if necessary, pay taxes, deal with any kind of debts that need to be paid. And then this is a private event. There's no recording of any of these documents usually. And that we can have some asset protection planning in a trust. So if you're probating assets or whether you are doing administration of assets, all depends upon how the individual asset is titled. The probate process in Massachusetts, you have some options based upon the value of the estate and as well as if there are any contested issues in the will. So the first and simple one is a voluntary probate. If your entire estate is $25,000 or less and you own a car or the decedent owned a car, then you can do a voluntary probate. I'd like to bring to your attention that if any real estate is owned, you cannot do voluntary probate because the assets are over $25,000. The next is informal probate. This is a little quicker. It has a little less court oversight. Oftentimes a magistrate is approving all of the documents. It still takes a year, right? Because probate has to be open for at least a year for creditor claims. And then the last type is a formal probate. And that is when the court is involved at every step and judicial approval is normally needed, is always needed in a formal probate. If you start as an informal probate because you think everyone is get along, go along, and then you go ahead and you try to get yourself approved as the personal representative and people are contesting it, well, you'll find your way to formal probate quite quickly. So oftentimes you'll just open up formal probate. It's a little bit more expensive than informal probate, but it is a sure path for knowing that you've started on the right foot and that any interferences that come up can be handled under a formal probate process. Timeline, I said, minimum of 1 year for formal or informal. And then the cost. Many people, because I do a lot of probate, I'm a probate attorney, our law firm handles probate matters. We don't do probate litigation, but we do probating of wills or non-wills. And that if there's real estate involved, you're normally going to be spending at least $4,000 to $6,000. If there's a lot of heirs, if there's a lot of assets, if there's anyone contesting the issue, you're going to find that your timeline is going to increase and your expenses are going to proportionally increase. So it is because of these issues, right? And that oftentimes extremely high expenses. It's not unusual for a probate to be in the $8,000 to $10,000 range. I've had them go as high as $45,000, $50,000, depending upon the number of heirs and if there are issues that are being contested. So depending upon the issues will determine the price. So this is why we want to avoid probate if at all possible. But again, if the decedent has already passed away, right, and that you're in the probate process, I don't want you to worry about, kind of all of these things that depending upon what the asset structure is will determine if it's going to be simple or not. And we as a probate attorney firm, we can walk you through no matter what comes your way. Conversely, for trust administration, if a revocable trust exists, you're going to have the trustee who takes charge. It avoids probate. They inventory all of the assets, and then they're going to start to, if there was a probate asset that had to go through probate, then we're going to retitle that into the name of the trust once we get through probate. The trustee is going to pay the bills, the debts, and they're going to work with the taxing authorities to pay any taxes, personal, estate, fiduciary tax returns. And then they're going to distribute assets per the trust instructions. Private again, and can normally be done in less than 1 year. Key responsibilities of the personal representative or the trustee. And I like to bring this to your attention because these are all of the same, whether you are going through probate or you're going to be doing trust administration. It's just the person who's doing them is different. The personal representative or the trustee, you're going to gather together all the assets. You're going to pay the debts and expenses. You're going to file final tax returns. You're going to communicate with the beneficiaries, oftentimes what the asset structure is with the will or the trust and the inventory of the assets. Once all of the debts are paid, you're going to distribute the inherited property. And then all the way along, you're going to be keeping good records, right? Especially if there is anyone that's questioning anything. Taxes, lovely, lovely taxes. I want you to think, actually, before I go here, I want you to keep in mind that whether you go to probate or whether you do estate administration, taxes are the umbrella over every type of asset, even assets that were distributed through a beneficiary designation form. So taxes of when someone passes away are determined at the moment they pass away, and if they had what the taxing authorities refer to as an incident of ownership. An example of that might be a life insurance policy. They have passed away, so you would think the $100,000 benefit on the policy would not be pulled back into the decedent's estate when determining whether there's a tax to pay. But in fact, it is. It is part of the evaluation because the decedent owned the insurance policy the moment they passed away. So that is considered an incident of ownership, and whatever the value of the proceeds are from that insurance policy gets pulled in for the tax evaluation. And this next slide is what is the evaluation. Again, this is in Massachusetts, and that we are saying these are the 3 types of taxes that oftentimes have to be followed. A final personal income tax return of the decedent, normally federal and state. Then there is an estate tax return. And an estate tax return, whether it is a trust, whether it is a will. So this is again, the umbrella of the taxes. And that's when we're looking at the incident of ownership. Does the decedent's estate rise above the $2 million threshold, right? That was a law change in 2024. Actually, that should say 2023, but 2024 is when the law changed and it was retroactive, or 2023 was. Regardless, if you die in Massachusetts owning $2 million or more than $2 million, you'll have an estate tax to pay. So some people refer to it as a death tax, but it's actually referred to as an estate. So it's a Massachusetts estate tax for passing away with more than $2 million. Federal, They just raised that in 2025 to 15 million. The fiduciary tax return is if you have an estate that is ongoing after you do your first personal tax returns, and then now you have either a trust or you have an estate bank account, and it's earning income or interest or dividends are being paid out. So anything where it's interest earning or income earning, or the sale of a house within an estate, that could be a catalyst for filing a fiduciary tax return, maybe after you have filed the death tax return, the estate tax return. So fiduciary tax returns may be required annually after you have filed the final income tax return, the estate tax return. And by the way, estate tax returns have to be filed within 9 months of death, or else you're going to get interest and penalties that will accrue. It's good to know that to work with a qualified tax professional to help you determine if there is any tax liability and to help you plan for your future. So we are very intertwined when someone passes away, especially if we think the estate is over 2 million, whether we're going to involve a tax professional or how quickly we're going to bring them in to help us figure out if there is a tax liability. Before I leave the tax screen, I do also want to mention one thing for a surviving spouse, that if when the decedent passes away and they are your spouse, and that you and them, right, as a couple, you might have had assets in excess of $2 million, that there are no estate taxes to pay, because a surviving spouse can inherit an unlimited amount of money from a decedent, from a deceased spouse. So if, say, you have $2 million or $2,100,000 and your spouse passes away, that you don't have to worry about filing an estate tax return or paying any taxes on the death of the first spouse. So it's really on the death of the second spouse that you're going to want to make sure your estate is under $2 million, either through gifting or using credit shelter trust tax planning. So, tools to protect your future. Check beneficiary designations on life insurance policies, retirement accounts, savings bonds, and other assets. And this is to facilitate distribution to the named beneficiaries. Oftentimes it might be you, right? But that this is where we're at least going to start corralling together the assets to then figure out, do you have enough money to live on moving forward for yourself? Or do you need to make some decisions on how we're going to start making other decisions so that you do have enough money to live on? So review and update beneficiary designations. If you are the named beneficiary of an asset, say on a retirement account, say, I want you to retitle the asset into your own name, right? So you'll take it as an inherited IRA in this example. And then I want you to name beneficiaries of this new inherited IRA that you received. And I want that to reflect your wishes of who you would then like those assets to go to upon your passing. If you're going to be doing estate planning, then we can also look into creating a whole plan and distribution of your assets upon your passing to avoid probate if you wish, using trusts. As I was just saying, you need to get your cornerstone legal documents in place. What does that consist of? A trust if you want to avoid probate or make distribution of assets private and simplify it. A will, either as your primary, if you're not going to get a trust, right? Then you would get a will, and that we know that we're going to be using the probate process to distribute assets that aren't jointly titled and don't have a beneficiary designation. Your power of attorney for finances. Before, if you had a spouse and they passed away, oftentimes spouses had a lot of ability at financial institutions to control the assets, especially in a jointly held bank account or an investment account. But when there's only you, you really do need to have either your assets held in a trust or use a durable power of attorney for finances to name someone to handle your finances in the event you become incapacitated. Or you don't have to have incapacity, you can also have it for mere convenience. So powers of attorney are written two different ways, springing or shifting, right? And one of them becomes effective the moment you sign it, even when you have capacity, versus the other one, the springing, only becomes effective upon your incapacity. I want you to get your healthcare proxy, your advance directive of whether you want to be kept alive on life support, and your HIPAA, who can get at your protected healthcare information. Because if the person that has just passed away was your go-to person in first position, then maybe they were the only one in that position, right? So I want you to update your legal documents to reflect your choices. If you have a healthcare proxy or a durable power of attorney or any legal document where you have successive people named in the position, if the first person becomes incapacitated or dies, then you're all set and you don't have to go and get your documents redone. So create, review, update your own estate planning documents, confirm or change your beneficiary and fiduciary selections. And this helps preserve your family wealth and ensures smoother transitions upon your passing. Consider tax and financial advice. Seek advice from an accountant or a CPA to understand the tax implications associated with retirement assets and estate and fiduciary and the personal tax returns, all of those taxes we spoke about earlier. Consult with a financial advisor for investment advice and long-term financial planning strategies. I am a proponent of the three-legged stool approach to getting your finances and legal affairs in order. You should have an estate planning attorney, you should have a financial advisor, and you should have a tax professional to help guide you through all of the decisions that you might have in front of you. Because between those three professionals, they will be able to counsel you on just about anything that comes down the pike. In addition, that oftentimes you can't make a legal move without it having a tax consequence. So it's important to have these three members on your team. Evaluate your finances, your income sources, and your tax liability. So assess your financial situation, including any sources of income and debts, while considering the estate taxes we spoke about earlier, as well as the personal and fiduciary. This will help you plan for the future and understand your own financial status and your financial needs. We next want you to notify any relevant institutions and agencies. So that is contact your banks, insurance companies, government agencies, and institutions to inform them of the decedent's passing. They oftentimes will provide you with all of the needed paperwork to transfer an asset if it's outside of the probate process, or even through the estate administration under a trust, transferring ownership to the new beneficiary. Some institutions will freeze assets, right? So you will not be able to get access to the account until a personal representative is appointed through the probate court. So keep that in mind, that oftentimes we don't run to the bank to let the bank know that somebody has passed away. I oftentimes like you to kind of get a hold of your financial situation, work with the attorney and the taxing authority and your financial advisor, and then we can kind of let a lot of the other banks and institutions know that the decedent has passed. In the event that assets are going to be frozen, we want to make sure that you have access to money. The last part is take care of yourself. Personal steps in grief, right? Allow time and space for your emotions. And it's being on an emotional roller coaster after someone passes away. Lean on your family and friends, your clergy or your grief groups or your support groups. Keep a routine. Eat, sleep, walk daily. Do allow your friends and family to help you keep a routine. I've had a lot of clients that have considered journaling very helpful. Memories, gratitude, their journey through grief, just as a way to get it out. And don't hesitate to seek professional counseling if needed. As many of you might know, if you're clients of mine, I've already sustained the loss of my spouse, my husband. And so I speak from experience here. It is very, very important to take care of yourself during your walk through grief. And take care of yourself emotionally and physically, right? Make sure you get out, move around, eat well, get some counseling if you need it, because your entire world just changed. So be kind to yourself. So, a quick review is that first, you need to, and you probably often have already done this, is the funeral and the death certificates need to be acquired. You're going to locate your legal documents and get in touch with the fiduciaries, the personal representatives, the trustees of the trust if necessary. You're going to secure the assets and notify agencies such as life insurance companies and things like that to get the assets into the new beneficiary's name. We're going to determine whether you have to do probate or trust administration. You'll have to pay debts and taxes no matter which avenue you go. And then once we've done all of the payment of the debts, and oftentimes kind of closed probate or starting to if necessary, and close the trust, you'll distribute the inheritance as part of that process. And then we want to make sure you update your own plan and beneficiary designations to reflect your wishes, and also to update your healthcare documents to make sure we have the person you want making healthcare decisions when you can't make them for yourself. So, conclusions and next steps: determine if you need assistance, and if so, contact any of the professionals that we spoke about already, right? Your attorney, your tax professional, your financial advisor, the personal representative of the estate, the trustee of the trust. So determine if you need help and then reach out for it. And emotionally, right? Your clergy, your mental health professional, whomever you need to get through this very difficult process. Create or update your own estate plan as soon as possible if needed. And I do say as soon as possible that it's really advisable because, again, we don't know. Someone asked me recently, what is it that I need to know from an estate planning perspective that most people don't really know, or that they just get it wrong? And I said, people always think they have more time than they really do. So embrace that, get things done as soon as possible, and then be kind to yourself. Just do the next best thing to move things forward. If you're feeling the pressure of the 30 days, don't. Do what you can. Reach out to people to help you, but just do the next best thing. Just reach out to move things forward. We're going to do some questions and answers now. You can put them in the chat if you'd like, and then I'll answer those first, and then I'll go to the group. I have some questions that are common that we'll start with. I think there's 4 of them. If I jointly held all of my bank accounts with my spouse who passed away, do I need to probate these assets? No. These accounts were jointly titled with rights of survivorship, so no probate was needed. You will likely need to go to the bank at some point, provide the death certificate of your spouse, and ask for their name to be removed from the account. We oftentimes don't want that to happen if there is a surviving spouse for at least a year, if we're not opening up an estate bank account, if there's no other trust administration being done, because we sometimes like to have a bank account with the deceased spouse's name on it, so that we can deposit checks that would come in their name. And that applies to actually just jointly held bank accounts. It doesn't even have to be a spouse who's passed away. Question number 2, if I didn't file probate, does that mean that I didn't have a taxable estate? No, absolutely not. As I said, the umbrella of taxes are over probate and non-probate assets. So taxes are evaluated on the value of all probate and non-probate assets. Avoiding probate does not mean that you avoid a tax liability. So you should contact your tax professional for advice. Question number 3. If my spouse used Mass Health for nursing home care, will I be subject to estate recovery and have to pay back the money they spent caring for my spouse? It depends. Mass Health uses liens and the probate process to collect any money they are owed by an applicant. That's the person that used the Mass Health services. If an applicant has a probate estate, it will likely be subject to estate recovery by Mass Health. Question 4. If my estate was valued at over $2 million when my spouse died, as the surviving spouse, do I have to pay a Massachusetts estate tax? No, you do not. A surviving spouse, and this is the only person that this applies to, is a surviving spouse, can inherit an unlimited amount of assets from their deceased spouse without paying an estate tax. If you have a credit shelter tax planning trust as part of your estate planning documents, you should contact your attorney or tax professional to fund your tax trust to avoid estate taxes upon the surviving spouse's passing. Because you want to make sure that if on the first spouse to die, that the estate was over 2 million, we might want to carve out some of that money, put it in a credit shelter trust for when the second spouse dies, that your estate is definitely under $2 million so that you won't have an estate tax to pay. So thank you very much for attending this webinar. All of this information was for general information purposes in general. It was not to establish an attorney-client relationship. I hope it's been helpful, and that if you are finding yourself in a situation where a loved one has passed away and that you need some direction, you can contact our office either by phone, or we have a website, guthrolaw.com, and you can go to that website. There's a probate questionnaire that you could fill out, or you could just call us or email us, and we could start the process by having you complete a questionnaire, and that will help us figure out and help you put together all the assets and debt. So it's also a very good form for trying to corral all of the information together in one place for you to figure out whether or not you have to pay an estate tax potentially, or how we're going to move forward. So we'd be happy to help you. And then if there isn't any need for probate, we tell you that as well. And then we would also give you instructions on how to work with the financial institutions, either to liquidate the assets through the beneficiary designation forms, or if it's a trust, we would elevate the successor trustee for them to then serve and have the power to make decisions to then distribute the trust assets. Thank you very much. I hope that everybody has learned something. And keep in mind that we do videos just about, or new webinars every other month, but that at the website at guthrolaw.com, you can find other videos under the videos tab at the top. And that if you do need us, you can contact us directly at 781-229-0555, or email us at office@guthrolaw.com, either directly or through our website. Thank you all very much.
If you would like help or have questions about this information, please give us a call at 781-229-0555 or visit our website at guthrolaw.com. We look forward to hearing from you.